Good morning, Sir Robert.
Good morning, sir.
In a moment or two, I'm going to ask Mary to ask you to take the oath. But first, let me just explain the arrangements. They're probably obvious, but in front of you, you have a large and reasonably well-packed room. On your left, there are lawyers. In front of you, there are members of the public and core participants and participants. At the very far back, there are representatives of the press. Others will be watching remotely, either here or elsewhere, on either YouTube or live stream. And the audience in total will number in the high hundreds, I expect. So much for today. We all know it's hot today. The hearing room is deliberately set at a fairly low temperature to allow people to concentrate all the better. But it may well be that you may wish to go out and bring in water and drink it in the room. That's entirely acceptable. Please feel free to do that. The last thing I would want is anyone to feel that the heat was in any way affecting them. If you do so, please do avoid disturbing your neighbour. It is important for evidence like this that everyone should be able to concentrate. And so bear in mind that if you feel that the need to talk to your neighbour, do so, please, if you can, in a way that doesn't disturb the concentration of those around you. That's enough of the headmaster from me. Mary.
Please state your full name.
Robert Anthony Francis.
Take the book in your raised hand and repeat after me. I swear by Almighty God.
I swear by Almighty God.
That the evidence I shall give.
That the evidence I shall give.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
So, Robert, I'm going to start with a quick précis of your career. You qualified as a barrister in 1972.
Yes.
And you became a Queen's Counsel in 1992.
Yes.
And the focus of your practice throughout your career as a barrister has been predominantly aspects of healthcare and medical law.
That's correct.
You chaired the public inquiry into Mid-Staffordshire NHS Foundation Trust, which I think began in around 2010 and reported in 2013.
Yes.
You've also chaired the NHS Freedom to Speak Up review, which was a review into whistleblowing in the NHS in England.
Yes, that was in 2014, reporting in 2015.
You were knighted in 2014, essentially for services to patients.
Yes.
And you are chair of Health Watch England.
Yes.
What is that exactly?
It's the statutory but independent champion of patients and service users for health and social care, NHS and social care.
And it's a statutory committee of the Care Quality Commission.
It's a statutory committee of the Care Quality Commission, who provide, as it were, infrastructure support, but we are an independent statutory entity.
Now, you've produced a report, the Infected Blood Compensation Study, entitled Compensation and Redress for the Victims of Infected Blood, Recommendations for a Framework. We'll obviously be coming back to the content of that time and again today and tomorrow. I just want to start by looking at how you came to be appointed.
Yes.
And so there's a handful of documents we'll go through. Lawrence, could we have, please, RLIT 0001123. This is an announcement, a written parliamentary statement made on the 25th of March 2021 by Penny Mordaunt, the then Paymaster General. And if we go to the second page, please, Lawrence. We've got the heading Compensation Framework. So if we can just have those paragraphs highlighted, or that, thank you. So to meet the government's commitment to consider a framework for compensation, we can confirm our intention to appoint an independent reviewer to carry out a study looking at options for a framework for compensation, and to report back to the Paymaster General with recommendations before the inquiry reports. The terms of reference of this study will be finalised in consultation between the independent reviewer and those infected and affected. The study will include consideration of the scope and levels of such compensation and the relationship between a compensation framework and the existing financial support schemes in place. The study is entirely separate from the public inquiry, which continues to have this government's full support. It will not duplicate the work of the inquiry or cut across the inquirer's findings. The study shall provide the Paymaster General with advice on potential compensation framework design and solutions which can be ready to implement upon the conclusion of the inquiry, should the inquirer's findings and recommendations require it. The name of the independent reviewer will be announced shortly. So that's the initial statement, and that's a broad description of what it is you then became the independent reviewer to undertake.
Yes. I should say at the time of this announcement, I frankly had paid little attention to it, and I certainly hadn't been contacted at that point.
And then if we go to RLIT 0001138, I don't need to read it aloud, but it's just to give us a date. This is an announcement on the 20th of May 2021, and this announced your appointment to undertake the study that had been described in the Paymaster General's previous statement.
Yes.
Now, the terms of reference for your study are at RLIT 0001125. I'm not going to read them aloud. I'm just going to identify the headings. So, rationale for compensation, independent advice to government, scope of compensation, categories of injury and loss, types of award and method of assessment. Over the page, measures for compensation, relationship with current schemes, options for administering the scheme, other issues. Reporting to the government by February 2022, which I think was subsequently put back by 2 weeks to the middle of March 2022. So those were your terms of reference. How were those terms of reference drawn up?
Well, the Paymaster General had issued some, as it were, draft terms of reference for consultation, and the idea was that I should hold a consultation and then make recommendations about the final terms of reference. That I did. It's fair to say that the time for consultation was relatively short because the job appeared to be urgent, but I did receive a number of representations from core participants to this inquiry and others, as a result of which I made recommendations to the Paymaster General, all of which, from recollection, were accepted and were in this document.
So these terms of reference, but built on an initial draft produced by the Paymaster General, but reflect your own thinking and the input of those during the consultation.
Yes.
And then, if we then can just pick up subsequent key dates and course of events. First of all, at RLIT 0001132, please. This is a statement made on the 23rd of September 2021 by Ms Mordaunt's successor as Paymaster General, Michael Ellis. We can see, if we go a little further down the page, under the heading Statement, I'm not going to read this aloud, but it describes the process of formulating the terms of reference and explains in the third paragraph that the Paymaster General is happy to accept Sir Robert's recommendations in full as to what the terms of reference should be. And then if we just go to the third page, please, Lawrence, to pick up the last paragraph of the statement, where the Paymaster General says this: I, like my predecessor, am deeply committed to ensuring that Sir Brian Langstaff's independent public inquiry has all the resources it needs to complete its work, in Sir Brian's words, as quickly as thoroughness permits. The infected blood scandal continues to claim the lives of infected people, and those directly affected have waited too long for answers and for justice. So that's the statement made as at the 23rd of September 2021. Now, you then embarked upon your work. Just so that there is no doubt or misconception about your role, you undertook your work entirely independent of government.
I did.
You were essentially asked as an experienced lawyer to come up with a review of what might be a fair and proper compensation scheme.
Yes. Obviously, one of the challenges being that it was very dependent upon the findings of this inquiry, which, of course, so there was a bit of egg before chicken, if that's the right expression about it.
But the aim of doing it that way, as I understand the public statements, and please correct me if this is not your understanding, is to try and ensure that essentially as soon as the inquiry has reported, if the inquiry's recommendations and conclusions essentially invite compensation, that the work would already have been done to then enable that to be established as soon as possible.
Yes, I think it's fair to say I regarded my task as to try and produce a framework of compensation independent of this inquiry, and I think the text of my report probably shows that. But yes, you're correct.
To what extent did... So we can take that down, Lawrence, thank you. To what extent did financial or economic factors or affordability play any part in your decision-making?
Only in very broad terms. I deliberately did not go into detail into figures. I sought to have regard to proportionality in relation to balancing the perceived wrongs and injuries inflicted on people and to have regard to other forms of compensation. But I did not look at, as it were, fiscal issues as to what might or might not be affordable by the government. And
is it right to understand you weren't given any sum or cap with which to work by the government?
No, I was given a blank piece of paper.
And then in broad terms, can you explain how you set about your task?
Well, I thought, first and foremost, it was extremely important to have regard to this is what I do at Health Watch England, is having regard to the lived experience of people who have suffered, in this case, from infected blood and blood products. So I needed to hear and also, of course, to read what many of them had said. Obviously, there was a background to be studied in terms of material available to this inquiry, but also other sources. So there was a matter of collecting evidence, but at the same time organising to meet people who wanted to see me, followed by some consultations with people who were already involved in providing support of one sort or the other in both England and the devolved nations. And then analysing what I'd heard. But all the time, it's right to say, I was conscious of the need, as expressed in the document you've just shown us, to get on with it. And therefore, I had to judge, and they were difficult judgments, to judge how many people I needed to see in order to acquire the information I needed. And that, I'm afraid, meant that I couldn't see or everyone that might otherwise have been seen and had been seen by this inquiry. Likewise, I cannot claim to have read every page of evidence submitted to this inquiry. But I hope I have done what was necessary in order to come up with an informed framework.
And did you, in the course of your work, receive any representations from the Department of Health and Social Care or anyone else in government as to what your recommendations should be? None at all, no.
That's not to say there weren't communications, as I think it's clear from the report. I did meet officials from the Department of Health, NHS Resolution and organisations like that in order to establish what was happening and what had happened in the past.
And were there any representations from any of the devolved governments as to what your recommendations should be?
No, except to the extent that there was an anxiety expressed by at least some of them to be involved, if I can put it in that way. They recognised that I was principally looking at the situation in England, but they wanted what was happening in the devolved administrations taken into account. But certainly there were no suggestions made to me as to what my recommendation should be.
Can we then just pick up a further few dates. You delivered your report on the 14th of March 2022 to the Paymaster General. Yes. And then if we look at RLIT 0001137, this is a statement made by Mr Ellis, the Paymaster General and Minister for the Cabinet Office on the 15th of March 2022. If we just zoom in on those 3 paragraphs of the statement, please, Lawrence. So we can see the second paragraph refers to the delivery of your report by you on the 14th of March. And then the third paragraph reads, I will now carefully consider Sir Robert's findings and recommendations. It is my intention to publish the study and the government response in time for the inquiry and its core participants to consider them before Sir Robert gives evidence to the inquiry. And then there's a reference to writing to Sir Brian about plans for responding and publication. I'll just look at a handful of documents with you, Sir Robert, and then just pick up on the issue of government response. So that's the statement on the 15th of March. If we look at RLIT 0001133, please, Lawrence. This is a written question by Dame Diana Johnson, and then the answer, if we go towards the bottom of the page, from Mr Ellis, 22nd of March. It's my intention to publish Sir Robert Francis's study alongside the government's response. Before I'm able to do so, you will understand that work must be undertaken within government to formalise our response. That work is already underway. I recognise how important it is for the inquiry and its core participants to have sufficient time to consider the study before Sir Robert gives evidence to the inquiry. It is my intention to publish the study alongside the government's response as soon as possible. So that's 22nd of March. If we then pick it up at RLIT 0001134. This is the 27th of April, bottom of the page. It's in response to a question from Ian Lavery MP, and it's the same message on the 27th of April. Ongoing funding of the Infected Blood Support Scheme payments is a matter for the Department of Health and Social Care. I recognise how important it is that the views of infected and affected people are reflected in Sir Robert's study, and then there's reference to consultation with those infected and affected. And then the last sentence, it's my intention to publish the study and the government response in time for the inquiry and its core participants to consider them before Sir Robert gives evidence to the inquiry. So that's the position as at the end of April. Now, your report was ultimately published on or around the second week of June of this year. So some weeks after the report had been published, had been provided by you to the Cabinet Office. As I understand it, the published report is in the same form as the report which you submitted. There's some minor textual matters about referencing and watermarks and so on, but
yes,
the content of the report is the same.
it is, and I have to say, given more time, in retrospect, having read it again for today, there are no substantive changes I would make, but the presentation wasn't as good in terms of headings as it might have been, but for which I apologise.
Do you have any understanding or knowledge as to why you, having delivered the report in the middle of March 2022, the Cabinet Office did not publish it until June 2022?
It was always intended, I think, that the government would take time to consider the report and publish a response at the same time as they published the report. I think that, and in terms of how long that was going to take, it was clear that the report had to be published in time for interested parties to consider it before it was formally produced at this hearing today. So there was a sort of outside time limit for it. You would have to ask the government about the detail of what happened in the immediate time. I only have sort of third-hand hearsay about that.
We will. Just to bring it up to date, RLIT 0001135. This is again Mr Ellis. If we go to the bottom of the page, this is in response to a question from Lisa Nandi MP. This is on the 20th of June 2022. There's reference to you giving evidence in the second paragraph, and then it says the government is considering Sir Robert's recommendations, and it is most important that the government is able to reflect upon Sir Robert's evidence and the evidence of others to the inquiry as part of that consideration. So it appears that as between the end of April and this date in June, the government's position has shifted from publishing the response as well as your study in time for you to give evidence to simply publishing your study. Have you had any discussions with Cabinet Office or anyone else in government that would throw any light on why the government's decided to take that course?
No, the only meeting I've had with Mr Ellis was on the day I handed in the report, at which point, obviously, he had nothing much to say about it, apart from thanking me, I should say.
And then the most recent, I think, communication of the government's position, and this is really just to complete the chronology of events and put matters into the open rather than the focus of any question for you, Sir Robert, but it's JEVA 0000129. This is a letter from Mr Ellis to Factor 8, campaigning organisation. We've seen, I think, letters in similar terms around this time to others, but this happens to be dated the 30th of June, and the second paragraph reads, I would like to emphasise that there is a great deal of complexity to the issues covered in Sir Robert's study. At present, officials from across government are conducting a thorough analysis of the report and its recommendations. That analysis requires careful and diligent work given the very many factors that must be taken into account. I should note that Sir Robert is due to give evidence to the inquiry on the 11th and 12th July. Following his appearance at the inquiry, officials will also need to factor in his oral evidence as well as the oral evidence of others appearing at the inquiry. Sir Robert, do you know, I suspect the answer to this is probably no in light of your earlier answers, but do you know what oral evidence of others is thought by the Cabinet Office to be particularly relevant to their consideration of your report?
No, I'm afraid I don't.
In terms of those with whom you have dealt at the Cabinet Office, I think your statement tells us you met Ms Mordaunt once and Mr Ellis once, is that right?
Before the publication of the report, and
Yes.
then there was one meeting with Mr Ellis on the presentation of the report, which is obviously afterwards, after the report was prepared.
And again, in terms of the question of what your recommendations should be or might be, have you had any dealings with any civil servants within the Cabinet Office as to what the content of your report should be?
No, the only contact I've had with the Cabinet Office, including senior officials in the Cabinet Office, has been about administrative matters.
I just want to pick up on the question of your recommendation for interim payments.
Yes.
We'll come back to some detailed issues relating to the scope of that recommendation at a later stage. But if we pick up your report at RLIT 0001129, and we go to, first of all, page 10. I just want to read out a couple of, 2 or 3 passages concerning interim payment and then ask you a little about it. So at paragraph 1.10, under the heading, The Pressures of Time, you say this: unfortunately, a disadvantage from the point of view of those who might be eligible for compensation is that there is little or no prospect of the scheme getting going before the conclusion of the inquiry. This is unfortunate for the many potentially eligible applicants who are now of advanced years or worryingly unwell. There are those who fear they will not survive long enough to see, let alone enjoy, the fruits of an award of compensation. This is a principal reason why I have recommended the unusual measure of an immediate interim award to those infected persons who are already beneficiaries of the existing support schemes in anticipation of, but before the scheme has been set up. If at all possible, it is a matter of justice that so far as possible the infected likely to receive compensation can receive at least a significant part of it in time to make a disposition of the award as part of their assets before they die. And then if we turn to page 29, please, Lawrence. Top of the page, paragraph 2.69. You say there is a compelling case for awarding interim payments as soon as possible to the infected who have already been accepted as eligible for the support schemes. Many wish to be able to settle their affairs before they die. Challenging though it is to do this before the scheme has been set up and is fully operational and before the conclusions of the inquiry are available, I suggest that such a payment should be made now, reflecting the minimum any infected person could be expected to receive under the scheme. I have suggested this is unlikely to be less than £100,000 in any case. Naturally, any such payment would be on account of any final award and may suffice for some who might not wish to proceed further. And then, if we go to page 122, under the heading interim payments, you set out in paragraphs 9.128 through to 9.137 in a little more detail your thinking about the issue of an interim payment and referring in particular in paragraph 9.128 the fear of many that they have not got long to live. Now you've described there a compelling case, but also that it's in some respects a relatively unusual step to take. What, in your own words, Sir Robert, what was it that led you to make, in fairly strong terms, this recommendation?
I think principally the impact the stories I heard and read had on me, as I believe they would have on anyone in relation to the dreadful experience the infected, if I can use that term, have had. And the pressing need, and it underlay the whole setting up of this review, the pressing need for people to know that there was something on the way, that their affairs could be settled as they got older and before they died. The government were clearly correct in the response we have had to say that the issues around this are very complex and across government. And it was clear to me, as I wrote what was not a simple report, that it would take time to set that up whenever the starting gun was fired for that. And it seemed to me that if the principle of compensation was accepted, something to wait until a fully fledged scheme had been set up and then set about giving compensation would be too late for many to achieve the justice they sought. I was also influenced, I think, by the remarkable achievements of the 9/11 compensation fund in the United States, which I deal with in an appendix, where there actually scheme was set up within months, actually. But the circumstances and political background to that were very different. But what I think I learned from that is that the sooner you can get compensation into people's hands, the more effective it is. So that's why, amongst other reasons, I put in my report, I recommended this. I also felt that if the entitlement to an interim payment was limited to those who were already deemed to be eligible by the support scheme as an infected person, identifying people and determining their eligibility should be quite easy compared to the more complex assessments required for, say, new categories of eligible people or others who hadn't yet got on the support scheme. So I thought that even if a scheme hadn't been actually set up, there was a mechanism and indeed an administration through which an interim payment could be made.
So as I read this part of your report, the two things you called on the government to do, or that you recommended to the government that they do now, whilst they took then the time to consider some of the longer term issues in more detail, was to accept in principle the setting up of a compensation scheme, and then to offer the immediate interim payment, which, as you say in your report, could be done through the existing scheme, so it didn't need to wait for what might be some complex machinery of a new scheme.
Yeah. And I thought also it might have the advantage that for some, I couldn't say how many, if the amount of money was generous, that might be enough for some people, which would therefore simplify the task of the scheme later on.
Was it your expectation that 4 months on from your report there'd have been radio silence on that issue from the government?
I'm afraid I've been in the business of looking at inquiries, reviews and so on for long enough not to have any expectations one way or the other. These are decisions for the accountable government, and I recognise that whatever it is I've been involved in isn't the only thing on their mind.
What I want to do next then is just to do a quick overview of your recommendations to get an idea of the shape of what it is and the scope of what it is you're recommending. And then to look at different aspects of it in more detail. And you'll appreciate, Sir Robert, a lot of what I ask will be questions that those representing core participants and those representing those who are infected and affected have been put forward, issues that they're keen to understand your thinking or know in more detail how things might work if your recommendations were accepted. So if we go back in the report to the executive summary, which starts on page 15. I'm going to come back to the question of compensation and moral case and principles. But so if we go over to the next page, bottom of the next page, we see there the heading coverage of compensation. In terms of the infections that would trigger entitlement to compensation under the scheme that you have suggested, you have suggested compensation for hepatitis C and for HIV.
Yes.
We'll come back to the detail of hepatitis B, but you've suggested hepatitis B would not be routinely included within the scheme that you've suggested, but that there might be a case for an exception for chronic hepatitis B infection with serious symptoms requiring treatment for cirrhosis.
Yes, I should say all I have said about hepatitis B is very conditional, and it's clearly a complex issue. And with all due respect, in the end, I think that was probably one of the principal areas which is for this inquiry to assist the government on. And
I'll come back to that issue again, but just in terms of outline. So hepatitis C, HIV included, hepatitis B, for the time being at least, not.
Yes.
Likewise, hepatitis D, which
except insofar as it was a co-infection
yes.
with hepatitis C or HIV or particularly extreme cases.
You then did not include VCJD.
No.
As I understand it, that a principal reason for that is that there is a separate scheme, the VCJD yes. Trust, for those who are infected with VCJD.
Yeah.
In terms of those who are at risk of VCJD, you have not recommended that that's a feature of the scheme?
No, but insofar as that's a risk applicable to all who are infected, then no doubt that's something that can be taken into account in the sorts of awards I was suggesting.
And again, I may pick up on that when we get to the range of awards. In terms then of the scope of eligibility, eligibility for infected persons you deal with at the bottom of this page. I'm so sorry, next page, Lawrence, my apologies. So you set out paragraph 213, 4 conditions for eligibility for the directly infected, diagnosis with hepatitis C or HIV, over the page. Condition 2 is applicant received 1 or more blood transfusions or blood products known to be capable of transmitting 1 or more of the relevant diseases. 3 is applicant received the relevant treatment within or from stocks created within the periods of eligibility employed by the current support schemes. or as an alternative, a different period. And I'll come back to that again, Sir Robert, in due course. And then 4, the applicant's infection likely to have been caused by the administration of a relevant treatment. So those are the 4 conditions for eligibility if directly infected. And then paragraph 214 deals with indirectly infected persons, so that they would be those, for example, who were infected through a sexual relationship by a partner. And then in terms of proof of eligibility, we'll come back to that, but you've urged a sympathetic and sensitive attitude without rigid adherence to legal concepts of proof. If we go then further down the page, you anticipate paragraph 216 that the estates of deceased infected persons may be able to claim.
Yes.
And then eligibility for affected persons. Is it right to understand you've recommended widening the categories of those who may currently claim? If we go over the page, you suggest an entitlement to claim to those in a marital or comparable relationship, children of an infected person, parents of an infected person, and siblings of an infected person. There are some qualifications in relation to those, which I'll come back to, but in broad terms, those are the principal categories of the affected.
Yeah.
You also recommend that carers may be able to make a claim. That's paragraph 218. Again, we'll unpick the detail of that in due course. And then at 219, you've suggested, is this right, a residual discretion to the scheme to make awards to other categories of affected individuals who don't fall within those that you listed above.
Yes, the trouble with any definition of eligibility is that there are likely to be cases that come outside, particularly where there are complex social and family situations. It of course is a potential extension because probably at the common law, many people in this category who would have suffered a mental injury wouldn't be able to claim damages, for instance, for negligence. But it struck me that there were people, both in the more clear eligible categories and this rather inchoate category, for whom there was a strong moral case for compensation.
In terms then of the types of award, if we go to page 23, so an infected individual or their estate who is eligible, you have identified in paragraph 2.36 5 components to the compensation. Injury impact award, and that's to reflect both physical and mental suffering.
Past and future.
A social impact award for past and future stigma and social consequences. A care award for past and future paid and unpaid care. An autonomy award for the aggravation of the distress and suffering caused by the direct physical and mental impact through interference with family and private life and autonomy, and a financial loss award for past and future financial losses.
Yeah.
Now, again, obviously, we'll look at these in a lot more detail in due course, but would it be right to understand that the social impact award and the autonomy award are not regular features of damages payments in a claim, for example, for negligence?
No, exactly. And they may, as defined in this report, to some extent overlap a little bit with each other, and there may need to be, I think, looking at this, further work done about how you define this. But it seemed to me that to be bound by the categories of damages recognised in Harvey's and McGregor's law of damages would be too limiting, and if there's to be a compensation scheme, that there was an opportunity to look at things in a slightly different way to reflect the real injuries that people were telling me they were suffering from.
And then in terms of those who are affected, the eligible affected, the components of the awards for that category would be an injury impact award for past and future physical and mental injury caused by their experience of the relevant infection consequences and or death of the infected person, where a recognised consequence of a close and established association with the infected person. So would it be right to understand that that's not going to necessarily be an award that's payable to every affected person? Does it require
No, it wouldn't be.
So it would require evidence
proof of some injury in that category. Yes.
Again, we'll unpick that in due course. But the Social Impact Award for stigma and social consequences, you identify for the affected.
Yes.
A Family Care Award, and that would be as an alternative to the care award claimed by the infected person.
Yes, and also instead of, I suppose, the separate award for care that might be for someone who wasn't otherwise eligible but had provided care.
A Bereavement Award payable to defined family members.
Yes.
And a Bereaved Family Loss Award to address loss of dependency. Yeah. Now, again, we'll need to come back to this in more detail, but just so that those listening can understand the term there, what do you have in mind where you refer to loss of dependency?
The Bereavement Award was intended by me to be the equivalent of what is awarded under the Fatal Accidents Act as a nominal, and some people would say unduly small sum of money, but it reflects the fact of the loss and bereavement as such. The Family Loss Award was more about, in effect, the financial losses relative families will suffer because of the death of the infected person.
If we just go over the page in terms of some other elements of the scheme that you're recommending, you suggested that in terms of whether the individual takes it as a lump sum or a periodical payment, that should be a choice for applicants. Again, for those who may not be familiar with the terms, periodical payments are what?
Periodical payments are, instead of receiving a lump sum which reflects both past and future losses, it is a payment by definition to recover future losses, which on the whole are thought to be regular. So, and they have to be ordered by the court in a damages claim, but they are these days in serious cases very frequently used to spread the payments over a period of time. They're always uplifted for inflation. They're guaranteed for life. It has the advantage of regularity of income, and it also has the advantage of assurance of security of the payment, which of course a lump sum doesn't, because you have a lump sum, then you have to work out how to invest it. And anyone looking at the newspapers in the last few weeks will understand how risky that can be.
But importantly, would it be right to understand one of the reasons why you say this should be a choice for the applicants is, in a sense, caught up with that idea again of autonomy?
Yes.
That for those for whom they have perhaps been given little choice over decades, this is something where they could exercise a degree of autonomy.
Yeah. That will have to be subject, I think, to some definition around what periodical payments can be for, because it's not every item in a damages claim that would qualify for a periodical payment. But yes, that's correct.
I think, am I right in thinking that in making this recommendation, you're looking at the nature of the awards which might otherwise, which reflect losses which are periodic in their nature. So it's not simply a choice between either having a lump or your money spread over time. You will get, as you do in common law damages, a lump sum for whatever a lump sum is appropriate for, and the losses which would otherwise come over a period. Every week you would get earnings which you don't get. Every week you pay out for a carer which you wouldn't have to pay, and treatment which you wouldn't have to pay, and so on. Yes. Those losses are periodic in their nature, and they may be either brought together in one payment in advance, if you like, which may be higher, may be lower than what it actually costs, or you may get it over time uprated for the appropriate rate of inflation.
Yes, sir, and I think it's probably worth also making it clear that the assessment of the entitlement is a once and for all assessment.
Yes.
It's not, that's the difference between that and the provisional award. It's not revisited at a later date. But you know at the date of the assessment you're going to receive X pounds per year uprated for inflation for the rest of your life. Or sometimes it's divided into periods. The classic example would be in relation to care costs, where it's known that as you get older or more disabled, you'll need more care. So there might be periods, uplifts of the actual amount over a period, but that would all be determined at the date of the first assessment, rather than constantly being revisited. So you get finality, but security.
And picking up that point on finality, the lump sum, if, for instance, let us suppose a lump sum had been awarded in 1980
Yes.
to someone, there would be no opportunity, no right for the individual to come back in 2020 and say, that was 40 years ago.
No.
It's a pittance compared to what that sum will be worth now. Please, can I have some more?
Yeah.
You can't do that.
No. Well, the theory in damages is that the recipient of the damages invest them wisely, and therefore that the money keeps up with inflation, but not necessarily changes in circumstances. That's correct. But that's the rough justice, if you like, that the system of damages gives us.
And as you pointed out, I think one advantage, it is said, of periodical payments is that the risk of a bad investment is shifted to the person who's making the payment.
Yes.
And it doesn't lie, as it otherwise would, on the shoulders of the person who has the money.
Yes.
And may need to invest it wisely.
And my professional experience would be that families who are in receipt of large lump sums worry a great deal about that very fact, and it's the periodical. Therefore, they welcome the periodical payments as a solution to that particular issue.
We can see from the paragraph immediately below that you have suggested that a past waiver of litigation rights shouldn't be a barrier to compensation, and that there shouldn't be a waiver of litigation rights required to claim compensation. I'll come back to what you say the interrelationship might be between awards under the scheme, court awards, and indeed what account might need to be taken of previous payments, current payments, and benefits in due course. So that's the basic architecture of the structure of compensation. In terms of the scheme that would deliver it, you considered a number of other schemes, and we'll look at some of them, but you considered the bespoke individual assessment model that's used, for example, in the Republic of Ireland under the tribunal established there, and rejected that. Briefly, what was the reason for rejecting that as the model?
Well, I come back to the message that was continually given to me by those who I spoke to and wrote to me, which was the need for something that would happen quickly as possible. As I think I said somewhere in the report, there was the conflicting demand, as it were, for something that was quick and easy to do, but also as detailed and in terms of its recognition of the individual as possible. And unfortunately, the two aren't really compatible. The more detail a scheme is required to look into in relation to individual circumstances, the longer it will take, the more information that's required, the more evidence and argument there can be. Unfortunately, as is apparent, I was unable to avoid all complexity. That's just impossible. But the idea was to try and produce something which had more easily understandable categories into which you could slot a case with perhaps the descriptions already available about a particular individual, but perhaps leaving the choice in some areas for someone who wanted a more bespoke assessment, say in relation to financial loss, could proceed to get it. The penalty, as it were, for that being, or the burden of that being, it was going to take longer, it would be more complicated, and their final determination would, by definition, take a longer time.
And so the model you came up with was what you described as a more standardised tariff-based model. And again, just really by way of overview, you envisaged that it might be possible to create categories in relation to the infections and types of loss, and then create a tariff. So if someone fell within a category of, let's say, the hepatitis C, liver transplant, profound psychological damage through treatment with interferon over years and so on, that would attract a sum of X amount of money. You gave some suggestions of figures, and again, we'll look at those, but you weren't suggesting, as I understand it, those would have to be the figures.
Oh, definitely not, no. It was just in order to give some reality to, if you like, to what I was talking about, illustrating what I was talking about.
As against that, you might have somebody who, I think a rather smaller number of cases in terms of those from whom the inquiry has heard, infected with hepatitis C, fewer side effects, successfully treated, fewer longer-term consequences, although we'll have to come back to the question of
the model it appealed to me, the reason I came up with that, having regard to it sounds different, a completely different area really, but the criminal injuries compensation scheme, which has a tariff for virtually every conceivable type of injury you might suffer at the hands of a criminal. In a sense, whereas here we are obviously dealing with a limited number of conditions, albeit very serious ones, with lots of complexity within them. And it seemed to me that if we could come up, or the scheme could come up with a grid and categories of severe, moderate, and less serious, you could slot people into those, and within each of those there would be a range of figures to recognise that one point would be a bit artificial to reflect all the many variations. I mean, everyone I saw's condition it seemed to be entirely different from everyone else's. So you do need to recognise that to some extent, but it's much simpler if everyone knows that actually I'm in case it's in that grid, and what we're talking about is the difference between that figure and this figure.
And as I understand your report, probably the principal reason for recommending an attempt to create those kind of tariffs was comparative speed. So it ought to be capable of being done more quickly than setting up a tribunal in which every individual's case was individually assessed at large.
And I looked in, as you know, in some detail at the Republic of Ireland scheme, which of course had an advantage which this scheme will not have, of starting much earlier in the process of people suffering from these awful conditions. But looking at the number of cases they process and the number of claims they have, it struck me, as was inevitable, it's pretty slow. And that I had confirmed to me that it's slow, it's complex, and it is, the experience would be very similar to bringing a claim for damages in negligence, which, as you and I will know, can unfortunately take years.
Is it right to understand that you contemplate that kind of tariff approach not simply for the injury award, but also for the social impact awards and the autonomy awards?
Yes. Well, I thought with the social impact award, I was actually tending towards suggesting there should be a single figure in each category, simply maybe by reference to time suffered, in that it's so unquantifiable, the different ways in which stigma and social impact has affected people, whereas other areas there has to be more room for looking at the individual circumstances. What I was really envisaging was that there is complexity in all this, but I was actually hoping that all that would be upfront and done on a generalised basis by the panels I've suggested, as opposed to requiring the individuals to, as it were, reinvent the wheel for each of their cases.
In terms of the care award and the financial losses award, would you envisage that in most cases those would be more likely to be done on an individualised basis?
On an individualised basis, but by reference to some standardised figures. I confess it's one of my biases in civil cases that an awful lot of time is spent arguing about how much per hour ought to be spent on for care provided. And actually, it seems to me that in a case like this, there ought to be just agreed standard figures which were applied and adjusted, obviously, to the length of time care was needed, for instance, and how many hours roughly it was thought it was needed, without having to produce, as would happen in Ireland, independent expert evidence in every case about how much nursing care was required, for how long, and so on.
Now, you referred there to the panels, and what you've described in your report is a medical panel and a legal panel.
Yeah.
Again, we'll come on to some detailed questions about how they might work and who might sit on them and what their full role would be. In terms of the medical panel, the initial role, at least as outlined in your report, would be to help identify these tariffs or grids and to identify what might be the features of something that was very severe or moderately severe, for example. Is that right?
Yeah. Well, it seemed to me, having had the benefit of reading at least some, if not all, of the evidence of the expert panels that have given evidence to this inquiry, that doctors are, this would be a slightly novel question to ask of them, but they are quite used to categorising conditions into stages and degrees of severity. And in some of the cases of these diseases, they probably have done that already. So it would, I thought that they could be asked to look at the range of cases, as they have already been in this inquiry, that exist and there is clinical experience of, and to be able to categorise people without, and they of course will not be awarding money to individual people, but they would be able to assist in what looks like something serious as opposed to less serious. They would need, I absolutely understand, to be informed by information from patients who've suffered in this way, because a lot of the suffering is about people's personal experience. But when we're talking about the same diseases, I'm afraid, it is not a denial of people's individuality to understand that they have common features.
And then, in terms of the role of the legal panel, they would have a role, first of all, in filling in the figures in the grid or tariff. So, again, if we took an example of hepatitis C, liver transplant, profound damage from attempts at treatment with interferon, as the relevant example, the legal panel would determine by reference to a range of sources, including but not limited to the sources that are used by courts when making damages awards. And they would identify what the range of figures would be for that category.
Yes, it is now common experience. When I first started doing personal injury work, which was far too long ago, literally barristers and lawyers would think, oh, well, that seems like the right figure for the case, without anyone quite understanding how mysteriously that figure arose. Whereas today, there's a comprehensive advice provided by the Judicial College based on the cases and professional experience as to what the range of figures should be for any particular injury. Happily, or perhaps happily in a way, that there are very few figures in their guidance, or very few categories in their guidance which one could easily apply to the situations in these cases. But lawyers in this field are very experienced at being able to draw from comparable conditions, which may be quite different, but actually have the same features in terms of suffering, in order to illustrate a range of figures.
And then, with these tariffs having been identified and the range of figures for each tariff having been identified by the legal panel, who do you envisage would then decide where an individual fell and what sums they should be entitled to for these various different awards?
Well, you then need a team of assessors, and I think I've said ideally they should be lawyers experienced in the field, as I believe they are with the Criminal Injuries Compensation Scheme. an alternative would be to train assessors to make those judgments. Personally, I think in the long run it would, although lawyers are notoriously thought to be expensive, more expensive for doing it that way, I think in the long run it would be cheaper to have people who have real experience in this doing that job rather than people who've been trained up for this particular purpose.
So that would be a job, even if done by lawyers, as distinct from the role of the legal panel.
Yeah. I'm not sure I could see an objection to the same people doing both. I mean, again, going back to the 9/11 scheme, all the assessments were made there on the basis of references to tariffs, but by lawyers. As a result, on the whole, the determinations were accepted, I think, in 99% of the cases.
And then, in terms of whether they are accepted or not, you would anticipate there being a process of internal review. So, if an individual applicant was unhappy with what the assessor had provisionally identified, there would be a process of internal review and then an independent appeal panel if the matter was not resolved internally.
I have to say, I was very keen, probably to the distress of my legal colleagues, to keep this as far away from the court as possible. I don't think it's possible to prevent there being an appeal by way of judicial review as a last resort, but everything I've tried to recommend is to enable something to be done as informally as possible, but as quickly as possible. And the more you become involved in the legal process, the less chance you have of doing that.
And your suggestion is that this scheme should essentially be administered by an arm's length body.
Yes.
So a body distinct from any government department.
Yes. Arm's length bodies hold. I should say that they're not politically popular in all quarters because it's another bureaucracy. It costs money to set up. It seemed to me that the needs of this particular group of people were such, and the needs for independence from government were such, that an independent body was needed, which of course is funded by the government, and ultimately there is a form of government oversight of it, but that legally they are responsible for their own decisions and run things in their own way. One of the issues that became very clear to me, certainly from the people I met and from correspondence we had, was that there is a complete absence of trust on the part of many infected and affected people and the government because of their experience over many years. And if they're to have trust in a system of compensation, they will require it to be independent. And the government, the sort of pragmatic need for that is that unless the victims, and I call them victims for this purpose, people who might make a claim, are confident in the system that's offered to them, they won't go down that route. They will still want to litigate if they can, and of course there may be obstacles in the way of that, but it will mean this issue is not solved.
And so in terms of your recommendations, you've made 19 recommendations. If we turn to page 33 of the report, I'm not going to read them aloud. I'm going to deal briefly with each of them because we'll come back to most of them in the course of the rest of the day. So recommendation 1 was a recommendation that the government accepts the strong moral case for a publicly funded scheme, irrespective of the findings of the inquiry. And I want to ask you about that once we've looked at the recommendations. Recommendation 2 concerns the diseases that would be covered, so hepatitis C, HIV, defined serious cases of hepatitis B. Recommendation 3 are the conditions of eligibility for those who were infected. We go over the page. Recommendation 4 is the conditions of eligibility for those... recommendation 4 is about the process of establishing eligibility, I should say.
Yes.
And I'll want to unpick a number of those points. Recommendation 5 is eligibility for those who were affected. Recommendation 6 then is this right, captures your idea about there being
Yes.
these tariffs with input from a medical panel and a legal panel.
Yes.
Recommendation 7 relates to aggravated and exemplary damages, and we'll come back to those concepts in a while. Over the page, recommendation 8 then sets out the 5 heads of award that you recommend for those who were infected, so the injury, impact, social impact, care, autonomy and financial loss awards. Recommendation 9 sets out your recommendations of heads of awards for those who were affected. Recommendation 10 is essentially, although you avoided giving figures, as I understand it, you were suggesting that the rate should broadly reflect common law damages and other compensation schemes.
I thought it necessary to provide some guidance for that, and for there to be a relationship between the compensation under this scheme and the common law in order to promote proportionality and fairness, to be honest.
Recommendation 11 concerns the interrelationship between awards and past or contemplated legal claims. Recommendation 12 deals with awards being final. That's final with no provisional element.
Yes.
Again, we'll come back to that. And then the lump sum or periodical payment that you've already described. Over the page, recommendation 13 is concerned with issues of interest or uplifts for inflation. Recommendation 14 is the immediate consideration of substantial interim payment. Recommendation 15 deals with matters such as interrelationship with benefits, taxation and the like. Again, I'll have some further questions in relation to that. And then over the page, recommendation 16 is the establishment of the arm's length body accountable to Parliament with independence from government. Recommendation 17 was that the scheme should include certain support services, including advocacy and advice and other matters. Again, we'll come back to that. Recommendation 18 was a degree of local delivery within each devolved nation. Again, I want to come back to that. And then recommendation 19 was that these proposals should be reviewed by government in light of the findings and recommendations of the inquiry and thereafter on a periodic basis and reported on to Parliament. And again, we'll come back to that. But those are the recommendations for when I, in due course,
Yes.
ask you about recommendation 4 or recommendation 9 or the like. I will, as I do so, remind those listening of what the recommendation is, because it's not otherwise necessarily easy to follow. But before we look at any of the individual recommendations in terms of mechanics, I just wanted to go back to the issue touched on in recommendation 1, this issue of the moral case.
Yes.
And indeed a moral case which you describe as strong and arising irrespective of the findings of the inquiry. What was it that led you to that conclusion?
Well, I hope I've set it out reasonably clearly in the first chapter of this report, but it's not in... When there is a disaster in which people are injured through no fault of their own, in many cases, even when if there's no one else to blame at all, the state will move in and intervene in some way or another. And in this case, albeit many people were telling me it was unsatisfactory, successive governments have done so in relation to this particular tragedy. In my view, one of the special features of this case is that whatever it can be said about fault or no fault, the injuries that have been inflicted on people, firstly, have been inflicted on them by the state, putting it bluntly. The state-delivered health service has done this to people. It seemed to me, and without wishing to prejudge this inquiry, that much of what happened, and it's not for me to make the judgment, was in retrospect avoidable. In other words, if we look back on things from now, it could have been avoided for many, if not all, cases. And while we do not have a law in this country which promotes legal liability on that basis, it seems to me that where there is such a widespread disaster as this, there can be a strong moral obligation on the state which inflicted harm on people when the state was in effect trying to do the very opposite, to put that right. And when people have suffered, as people have here, their entire lives, which is another exceptional feature of this case, then putting that right is not just a matter of an apology, sympathy, and one would hope, and perhaps that's not always happened either, proper material support in relation to medical help and so on, that it can only be put right by, insofar as anything can be, by money. And that is a measure of the gravity with which the public, represented by the government, see this particular issue. And so those are, in overall terms, it seems to me, the grounds I felt produced a strong moral case. And I've cited, and I've looked in some detail in the report at the pronouncements made in the past about this by government figures, and trying to look at what the rationale was behind the support schemes, which hasn't, and I don't think I'm prejudging anything here, always been entirely coherent. But what it reflects was this instinct, both political but also human, that these were a very unfortunate group of people who had been damaged by the state, that it probably had been avoidable, and they needed to be put in, as far as possible, back where they would have been if this had been avoided. So for those reasons, I consider there was a strong moral case. And if I may also say, one of the reasons that I looked at was, and there's been evidence given about it recently, that a lot of the decisions that seem to have been taken about support seem to have been around a wish to avoid accepting a legal liability, when actually what needed to be looked at was the moral case for looking after people.
And you referred in your report, amongst other governmental pronouncements over the years, to the then Prime Minister, Mr Cameron, identifying this as something that should not have happened.
Yes.
And it's perhaps also worthy of note before we break that the Department of Health, in its opening submissions to this inquiry, said this acceptance that this should not have happened is an acceptance that things went wrong, things happened that should not have happened, and what was said to be an unreserved apology was offered. I say unreservedly, we are sorry that this should be so, that this happened when it should not have done.
Yeah.
And that is also, I think, from your report, an element of
Yes.
this moral case.
Well, I just personally, and it is a personal view, but I'm an independent reviewer and was asked to put a review forward, that to bedevil this area with the strict legal position about negligence is to overcomplicate things. And I appreciate when government ministers say this should not have happened. That's a very high level, almost not superficial, but it's a high level, undetailed examination of what is a very complicated picture. But if the general feeling is this is something that should not have happened, and in retrospect there are ways of stopping it happening, then it seems to me that is in itself a strong moral case for compensation.
And you set out in your report, I'm not going to go through them, but it's paragraphs 4.64 through to 4.74, and for those who are following the report itself, it's pages 58 to 59. But you've set out a number of factors that
Yes.
seem to you to be significant in identifying the strength of the moral case, including all the matters that you've just summarised in your answer, Sir Robert, but also you've referred to what I think you describe as a roller coaster of raised and dashed expectations. So you've looked at how, over years, the state has responded or not
Yes.
responded to the plight of those infected,
Yes.
and drawn that in as part of the moral case as well.
Yes.
So I note the time, perhaps a convenient moment for the morning break.
Yes, it is. But before we do that, let me just ask one question, which arises out of your discussion with Council about the arm's length body. The reason why I think you would prefer a body independent of government, but not a court, is that if it were a court, there would be the delays caused by, the formality caused by process, the probable need to involve lawyers. You didn't say that, but I think that's at the back of it.
Definitely.
And the costs necessarily involved and the time,
Yes.
none of which make for the justice which appeals to you. One of the dangers with an arm's length body may, and maybe that I have representations about this in respect of the various bodies which were set up at some length from the government. Quite what length it was is a matter for my determination. But McFarlane, Eileen, Caxton, Skipton. That they may not, because of their size, have been adequately staffed or equipped to deal with everything which arose. Was it part of your consideration to whether a tribunal within the tribunal service might be the arm's length body? As part of the tribunal service, it would be what is increasingly recognised as part of the court system, but not a court, with the advantages of informality, speed, experienced chairman, and independence, plus the clout and oversight that comes to reinforce that independence by being part of a system with the senior president of tribunals, a very senior judge, at its head. Had that crossed your thinking?
It's not in the report, sir, but I did consider that. I think the attraction to me of an arm's length body, and I should hasten to add, I don't see an arm's length body being comparable to something like the McFarlane Trust. I see it being more comparable to something like the, but obviously not as large as the General Medical Council, that sort of arm's length body. Is that that there will be a degree, we need administrative flexibility within this. We also need, it seems to me, the direct oversight of accountability to Parliament for the administration of this scheme and its funding. And I wouldn't have been, I don't think I would be persuaded that the tribunal service in itself would be able to provide the support actually required to the claimants, the expertise required, because it's not just an expertise sitting on a tribunal, it's an expertise of maybe investigating some things, but looking into things. There are a whole range of functions which it seems to me would be better done by an arm's length body in terms of, say, administering advocacy, support, communications of a supportive nature with claimants and a wider community, which don't sit, to my mind, happily within the tribunal service. I could see, I think, the tribunal service being a route of appeal and having oversight in that way. But I just feel there's too much going on, or will be going on, for the tribunal service itself to accept. And also, I would not like to see, in terms of the funding of the administration of this, that to be diluted with or competing with the other considerations of the budget of the Ministry of Justice, if I can put that fairly bluntly.
Well, that's very clear. Thank you. Well, we'll take a break now, in that case, until 11:45. Let's make it 10 to 12. 10 to 12.
Okay.